And pretty much what is being done today is what was done then. Of course, the difference is that you use the LNDO there, and today you are using the income tax. You are also using things like the ED. Now, you know, for example, the Enforcement Directorate are persons who slap a money laundering case on you. And because of a very unfortunate recent judgment of the Supreme Court, undoing my earlier judgment, it becomes very difficult for persons to get bail in these cases. The ultimate conviction rate may be 0.2%. So there's no hope of your being convicted, but you will not be let out on bail. So if the coercive machinery of the state is to be used in this fashion, then there's no doubt that the chill effect or the chill factor spoken about in all our judgment comes into full play. I may be pardoned now for reading another fantastic passage, which is again quoted time out of number in our judgments, by Justice Brandeis of the US Supreme Court in Whitney versus California. And pretty much everything that I have said so far is covered in this very beautiful passage. I might read it to you. He says in this case, those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. Remember Near versus Minnesota. That the greatest menace to freedom is an inert people. That public discussion is a political duty. And that this should be a fundamental principle of the American government, substitute Indian government. They recognized the risks to which all human institutions are subject. But they knew that order cannot be secured merely through fear of punishment for its infraction. That it is hazardous to discourage thought, hope, and imagination. That fear breeds repression, that repression breeds hate, that hate menaces stable government. That the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for all evil counsels is good ones. Believing in the power of reason as applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed. Fear of serious injury cannot alone justify suppression of free speech and assembly. Men feared witches and burnt women. It is the function of speech to free men from the bondage of irrational fears. To justify suppression of free speech, there must be reasonable ground to fear that serious evil will result if free speech is practiced. There must be reasonable ground to believe the danger apprehended is imminent. There must be reasonable ground to believe that the evil to be prevented is a serious one. Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. To courageous, self-reliant men with confidence in the power of free and fearless reasoning, applied through the processes of popular government, no danger flowing from speech can be deemed clear and present unless the incidence of the evil is apprehended and is so imminent that it may befall before there is opportunity for full discussion. If there be time to expose through discussion falsehoods and fallacies to avert the evil, by the processes of education, the remedy to be applied is more speech, not enforced silence. Only an emergency can justify repression. Such must be the rule if authority is to be recorded with freedom. Beautiful words. I may be pardoned for just one more quote before ending, again by Justice Jackson. And this is from another celebrated judgment in American Communications versus Dowd, where he says that thought control is the copyright of totalitarianism. We have nothing to do with it. It is not the function of government to see that the citizen or prevent the citizen from falling into error. It is the function of the citizen to see that government does not fall into error. Beautiful put. Beautifully put. I may only end by saying that ultimately every one of us as a citizen of India has a fundamental duty under Article 51 capital A to abide by the Constitution and follow its noble ideals. Ideals are in the preamble, which I've already spoken about. The authorities equally have sworn an oath to the Constitution to uphold and defend it. And our Supreme Court, so far as freedom of speech is concerned, has spoken continuously and in one voice. And these are the four things that it has clearly laid down. First, that freedom of speech and expression is what we call a preferred freedom. Why is it preferred to other freedoms? Because it is crucial for the proper functioning of democracy. First. Second, if you are going to make curbs, you the government, those curbs have to be under very narrow and stringent limits. All the limits that there are in 19.2, which I have spoken about earlier. Third, that any ban of an uncertain duration is anathema to free speech. And for that the chill effect on free speech is something that is to be eschewed by all, most of all by the government. I would therefore call upon the government to live by the noble ideals of our Constitution and this great fundamental right. Withdraw the present ban, withdraw the coercive action after the ban, see that no such bans are made in future. Try and genuinely prevent free speech. Because unless this is done, we are a sovereign democratic republic in name only. Thank you all very much.